On the record in the matter of portfolio recovery versus Dakira Love, 24-05798, council appearance.
Good afternoon, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Ma'am, state your name, please.
Dakira Love.
Okay, today was the date that was scheduled. This is for a motion for summary disposition that was filed by the plaintiff. Ms. Love, did you get a copy of this motion?
Yes, Your Honor, I did get a copy of the motion, and then I did file a motion of my own and a response to their summary.
Yeah, and Your Honor, I see that there's a date stamp on that response of November 13th. I received it in the mail on Friday, and it came across my desk today. So I'm just getting a copy of what she filed.
Okay, yeah, I see that ours was date stamped 13th for the court.
Yeah. And she, according to the court rules, she needs to serve it upon the plaintiff 5 days prior to the motion date.
Okay, did you file a copy or did you serve a copy that is upon the plaintiff?
Yes, I did serve a copy upon the plaintiff, Your Honor, and I did take a photo of that.
Okay, what day did you serve it?
I sent it the same day that I filed my response and put it and submitted it to the court.
Right, but that's
so
not.
It was well. Please don't interrupt me. That was well before 5 days before the court date. So, if I could just grab my phone so I could give you a specific date, Your Honor, I apologize. I didn't have my phone right in front of me.
You can do that.
Okay, one moment. Thank you. I appreciate your patience, Your Honor.
Your Honor,
I'm sorry, but I served it on time. And the same day that I filed it with the court.
No, ma'am, if are you looking for your receipt, you can continue to look for your receipt if that's what you're doing.
Okay. Let's see. Oh Lord.
Okay, Mr. Werber, were you looking for time to respond to this response? I'm not sure what you're looking for.
I was just stating to the court for the record, service isn't the date it's mailed. Service is the date it's served upon the plaintiff. And I wasn't served with the copy until Friday, which is not pursuant to the court rules. I need to be served 5 days prior to the motion. And I was not served. It's not when it was mailed. It's not when it was placed in the mailbox. It's when I receive it, when I'm served with it.
Okay, well, if she put it in the mailbox on the 13th, you should have received it before Friday.
Not with my experience with the mail lately at all. But either way, I'm ready to move forward with the motion.
Friday the 22nd? You mean to tell me it's going to take over 7 days for you to get mail at your office?
Yes.
Oh, okay, well then she served it. You can proceed. Okay,
so this is plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was originally a Best Buy credit card issued by Citibank. The defendant took out the credit card on November 15, 2021. The last payment made on the account was March 23rd, 2023. That last payment is reflected on the invoices attached to plaintiff's motion and attached to the complaint. The defendant, it seems like defendant's only issue here is the assignment. And she cites a lot of case law that I'm very familiar with regarding failure to prove an assignment. But in this case, and you can see what's attached to plaintiff's motion for summary disposition, there is not only a bill of sale and the redacted line item showing that this particular case was assigned to the plaintiff, there's a letter from Citibank that was mailed to the defendant, and that's attached to the motion informing her of the assignment. There's also
pages, what exhibit was that? Because they entered mine with different exhibit pages. Which, do you know which attachment it was?
Yep, I'm getting there. So the last two attachments to our motion are probably the most important. So the second to last exhibit in our motion is a letter to the defendant. And I'm looking at her current address. It's the same address that she currently lives at. And it's a letter from Citibank informing her that this debt is now owned by Portfolio Recovery. It provides the phone number if she would like to reach Portfolio Recovery. And it says, in case you have already sent payment to Citi, the payment will be forwarded to Portfolio Recovery Associates, LLC. So that is clearly proof that the account was assigned from Citibank to Portfolio Recovery. It has, like I said, defendant's name, her current address, the last four digits of the account number, all in that letter from Citibank. Then the last exhibit attached to plaintiff's motion is an affidavit from the plaintiff, again, testifying under oath that this account was assigned to the plaintiff. So the case law that defendant cites in her response, all of these cases had maybe just a bill of sale or just an affidavit or just one thing showing an assignment. That may be enough to prove the assignment, but in our case here, we have 4 documents to prove the assignment. Not only the bill of sale and the redacted line item, which is probably enough to prove an assignment, but we also have that letter from Citibank and an affidavit from the plaintiff. There's a Ohio appellate court, a 2005 Ohio appellate court case that said an affidavit is enough to prove an assignment. Again, I can go through each case that defendant cited if you would like. I'm familiar with all of them. But most of them just provided one thing to prove the assignment. And the courts ruled in some cases it wasn't enough, in some it was enough. In our case, and what the courts all say is you look at a totality of the exhibits provided by the plaintiff. And you see, Judge, we have multiple months of billing statements mailed to the defendant, showing transactions, showing payments made. We have this redacted line item. We have the bill of sale plus the redacted line item, plus this letter from Citibank, which I think is the most important document. It clearly states that Portfolio Recovery is now owns the debt. And then we have an affidavit from Portfolio Recovery. So reading over her answer and reading over her response, it's very lengthy, but I'm getting down to the one issue, which is she's not satisfied with the assignment, but plaintiff has provided more than enough to the court to prove that this account was assigned to the plaintiff. She's not disputing that she owes it. She's not disputing that she had this account, just that she doesn't want to pay Portfolio. And she wasn't a party to that assignment. She's a third party to the assignment. She doesn't get to pick and choose if it's assigned or not. So pursuant to MCR 2.116C9, defendant has failed to state a valid defense. Pursuant to MCR 2.116C10, there's no genuine issue of material fact. There's no need for us to proceed to a trial. Plaintiff has provided more than enough documents to prove the assignment and to prove the defendant owes the money. And plaintiff is entitled to a judgment here.
Thank you. Ms. Love, did you want to respond?
Yes, thank you, Your Honor. First, I'd like to start by addressing what the plaintiff said about the letter that was sent. I wasn't going to speak to that because I wanted to stick to what I believe to be the material issue here is that they don't have a valid assignment, which is outlined in the numerous case laws that he stated. But there's not even an affidavit from Citibank attesting to the validity of this letter. And even if he speaks on the payments, which again, we need to, I feel like, focus on if they own the debt first before we even get to the payments. But let's just to entertain him. The address on this letter that they claim that I received from Citibank, which is not true. I never received that, doesn't even match the address on the statements. And then on top of that, the computation that they say came from the original creditor is not the computation of the fees of the statements that they themselves attach. So I believe in that letter, it says that there was $269 in fees, but then the statement that I received that they attached says there was $350 in fees year to date. So again, I just wanted to point that out since he says that's one of the most important documents. And then to talk about the bill of the sale. Yes, in the case laws that I have provided, national case laws, state case laws, clearly state that the bill of sale has to be specific. It has to be specific of the debt. It does not have my name in it. It does not have the debt amount. Your Honor, the bill of sale that I'm looking at right now wasn't even signed. So how is it a sale if it's not signed? If this is supposed to be a chain of title, if I go and get a title for my car, I can't take it to the Secretary of State without it being signed. There's nothing they will do with that. Additionally, he stated that I didn't even deny the amount. I don't owe these guys. That's the main thing. I don't need to discuss what I had with the original creditor if they can't even prove that they have standing to sue me in the court, that they are legally able to sue me. And then statute of frauds. There's no assignment. I never agreed to anything to them. I've never even had a conversation with them over the phone. I've never had any correspondence. In this affidavit that he claims that backs their pleading was that it was dated like 3 months before they even filed the complaint. So Your Honor, I was very clear in my defense. My defense is that I do not owe them. And I've listed the numerous case laws, national case laws for portfolio. Number one, they're violating a consent order. They had a consent order from the Consumer Financial Protection Bureau of their frivolous lawsuits that they bring against defendants, which clearly states that they are not supposed to pursue any lawsuits if they do not have creditor original level documentation, which they don't have here. They attach, Your Honor, this 2-column spreadsheet that doesn't have the original creditor name on it. And then, Your Honor, the sale file or these documents that they describe in the bill of sale is not even attached here. So how can I even interpret the bill of sale without them not even attaching the files here? In the sale file, Your Honor, if you notice, they have this, pardon me, Your Honor, for flipping through my pages, but they have in this bill of sale, number one, they have what they call a master purchase and sale agreement. It's not here. So number one, I can't interpret what they're talking about. Even if Citibank can even say they sue me, because Citibank securitizes all of their credit cards. So this is in a trust. They put that out there for public information. And then number two, Your Honor, and what they identify as Exhibit 1, it says electronic file identified as PRA Best Buy Fresh Flow 1223. They did not attach that file. What they put in here is a 2-column spreadsheet that anybody can use. I use Excel on a daily basis, Your Honor. We all know that book 1 is not the same as book _1. But the sale file here says port rec _ and then etc. So to my defense is that no, they don't have any legal standing. They're not a real party of interest. They have not provided proof that they own this debt. And I would like to also note, Your Honor, that I was not served properly. Thank you.
We're not served what properly? The lawsuit?
Yes.
Okay, well, you've waived service because you've appeared. Once you appeared, you've waived it, that issue. As to the issue of whether or not there's valid ownership of this debt by the plaintiff, I understand your disputes. I just disagree with them. There is clearly here a bill of sale. It's signed. It states here the bill of sale and assignment dated December 21st, 2023 is by Citibank, a national banking association organized under the laws of the United States. It states the location. It states who the assignment is going to. It's signed by Citibank. It's signed by authorized title party, and it's also signed by Portfolio Recovery. It identifies in Exhibit 1, which is attached to it, the sale ID and the lot number. There is some information that's redacted. That would be the number of accounts and a cutoff date. That redacted information is something maybe if you wanted to discover further, you could probably do that if this was to pursue to a discovery period. But also there's another attachment that goes through account numbers and prior account numbers. It has your address on there, your date of birth on there. It has a consumer zip code for you on there. These are all the same address and contact information that was the same information that appeared to be on the original statements. In addition to that, they provided a copy of a letter that was sent to you, notifying you that this debt that you had accrued was being transferred. I don't believe that your dispute that they don't have proof that it was transferred or that they are lawful owners of this debt. I don't think it holds any weight because they provided the proof. And unless you can say that this proof is fraud, which citing statute of frauds does not mean that this is a statute of fraud issue, because this is not a statute of fraud issue. Nonetheless, I don't find that you have provided sufficient information or evidence to support your dispute as to whether or not they had a valid bill of sale or assignment of this debt. They provided that to the court and it was provided to you. If you don't like that that was provided or that there was a sale, that's personal, but you don't get to now decide that you don't have to pay this money back, that you don't dispute you owe to or may have owed to Best Buy. You're just disputing that they can now purchase the debt. Debts are purchased often. I think you're aware of that. It looks like you've done a lot of research or you have some experience in this area. In this particular case, the court's going to deny your objection to their motion. I'm granting their motion. I don't believe that you presented a valid defense upon the which the court can move forward with. I also don't believe that there's a genuine issue of material fact. You're not disputing the debt, you're disputing whether or not they have a valid assignment. The court deems the information provided for the court as a valid assignment. So motion for summary disposition is granted. Did you provide a copy of an order with your motion?
Your Honor, may I say?
Yes, Your Honor. The order is after the brief, but before the exhibits.
Your Honor, but I have a question. You said
nope. I've rendered my order. So
but you
I'm
read
done
off
with
my birthday. You read off a document. I have no clue what document you read off. You read off my birthday.
It was an exhibit. It was an exhibit. I didn't read the date that was on there. It was an exhibit that was attached to their motion. The first question I asked you was, did you receive a copy of their motion? You said you did.
Are you talking about the 2-column spreadsheet?
No, I'm not talking about a spreadsheet.
That's what I'm saying. I don't know what I have their motion. There's not, the only thing that had my birth date on here and everything else was a 2-column spreadsheet. There's nothing.
I apologize. I apologize. I'm not going to put a document on the screen that has private information that probably should be redacted if it's going to be public. This is a live streamed viewing at this point, and the court is open to the public. But I did indicate to you what the court had reviewed, and you, I'm confident, received a full copy of the full packet, including the motion, the brief, and any attachments. Even outside of the date of birth issue that you're now rehashing, the court is satisfied that there was a proper assignment of this debt. And so there's no issue of material fact to proceed to a trial on this matter. So the court is granting the plaintiff's motion. I'll sign the order that was provided and you'll receive a copy of that in the mail, Ms. Love. Any additional matters for the record, counsel?
No, thank you, Your Honor.
Any additional matters for you, Ms. Love?
No, Your Honor, thank you.
Thank you, you're all set.